The next slot is Deputy Higgins. You're going to take the next slot, please.
Thank you very much, Chair. And thank you to everybody for being here with us today and sharing your own perspectives on what is a very lengthy bill. So appreciate a lot of work went into that, and you've come here with very detailed views, and thank you for that. I suppose what all of us want is an efficient and effective planning system with transparency at the heart of it. And really, as a committee, what we're trying to get a handle on is the feedback of stakeholders out there into how we can make sure that this bill achieves that. From the IEN, I know you really have articulated concern that some provisions in this bill may end up being counterproductive, in that rather than speeding things up, they may risk delays if they're open into legal challenges or restrictions from that perspective. So I'd like to ask you about that. But another thing that's come up in the course of these discussions, and the RIAI raised it, is the e-planning system. And I suppose while you're talking about the electronic system going a little bit further than what's currently envisaged and provided for, I'd be really keen to know the IEN's perspective on whether or not you feel the current system, and I know it varies from local authority to local authority in terms of how quickly planning applications can be scanned and put online for members of the public to see it, whether you see that as a barrier to public engagement when it comes to planning. Thank you.
Second thing to note is the current judicial review situation is that developers are judicially reviewing development plans. So there's a third of all development plans in the country are currently under judicial review by developers and landowners. So whatever about the public taking judicial reviews, it's the development plan that's quite concerning for developers. So I think we need to have a robust system to make sure that the plan that is adopted is secure. In terms of the access to information, it's funny, I just got an email there for a client where a planning application went in on the 22nd of February, which was last Wednesday. And I've asked the local authority for a copy of the plans to be put online, and I get the email saying they're not up yet, they will be in due course. So we're a week into the 5-week period, that's 20% of the time is gone, and my client still can't access the information.
Do you think the onus should be on the applicant to provide everything in electronic form so they're available from the off?
Yeah, absolutely. So like in this day and age, all planning documents are created electronically. But I think the onus should also be on the local authority to make sure that all of the information is available in advance of public participation starting. So they can take as long as they want to put it up online, but the clock only starts when I can access the information, not when the planning application goes in. And I know it's incredible that it's controversial, but you know, you can't say you can participate in the planning file if you can't access the file. And there's actually our House Compliance Committee case law that says that that's a breach of the Our House Convention.
Well, I suppose they could argue that you can go into the local authority and request to see it.
Yeah, but in the Our House Convention actually requires electronic publication.
Okay.